But I have to recording in progress. This is a very promising news. So what I wanted to say that we are organizing it together actually with other organizations. And in the invitation, probably you have seen the list of these organizations who are representing Roma rights, disability rights, and refugee rights, and also hopefully in the future, LGBT rights organizations will join us also. So we are trying to represent actual organizations who are covering different fields of human rights issues, human rights protection. And as we said actually at the beginning, we are planning to discuss today the discrimination in EU funds. And in particular, now we will be focusing actually on the role of fundamental rights institutions, both at the national and EU level. Colleagues who joined us actually in September, you have seen actually several project examples, what colleagues presented from all over Europe, again, covering Roma rights, disability rights, refugees rights, and different other things. And the main issue was here that to make some, let's say, awareness raising around the question that, yes, unfortunately, with the use of EU funds, human rights violations are happening. And then I have to emphasize that because even actually we are working, or we have been working actually on this issue for many, many years, the awareness on this question is not so high still, but colleagues, probably the speakers will highlight this angle a bit more. So we need to make still some awareness raising. So that was our, let's say, aim in September. And we are continuing actually this discussion today with the role of the fundamental rights bodies. And this is not the last one. So we would like to continue this dialogue with you, and we would like to touch upon some other perspective, other aspects of these questions to make the full picture what's really happening actually with this problem, and how we can really, let's say, respond to these human rights violations in EU funds. Not an easy subject. And the people who are sitting here, like who will be speaking, they can tell you actually that after so many attempts, complaints, litigations, everything, still we are somehow feeling a kind of frustration. And that's probably our main, let's say, issue here today, that how to continue this dialogue and what could be the potential responses for the future. Okay, so now I spoke too much probably, and I would like to ask the speakers to introduce themselves just very briefly, 1 or 2 sentences. And then, as we discussed earlier, actually, we try to keep the presentations actually short, like 8, max 10 minutes. And then we will have some time actually for the discussions. We will have an open facilitated discussions when people, they can bring up basically any issues. But still you will have time actually to reflect on the presentations as well. I will call actually the participants to have questions if they have any. Okay, Valentina Stoeva, who is representing actually the EU Ombudsman Office, please, the floor is yours, and she will be speaking actually about the inquiries while the EU Ombudsman Office actually was launched in different fields. Valentina, the floor is yours.
Yes, thank you very much. Thank you very much for inviting us, for having us. It's really a pleasure to have our office, and I very much also look forward to the other presentations, to the discussions. These are matters that we are involved as a result of complaints or as a result of own initiative inquiries of the Ombudsman, so very, very important topics for our work. First, a word of introduction on the next slide. I know that we know some of you closely. Maybe others do not know us so well. So I just wanted to mention what we do. What's the task of our office? It is to ensure and to hold to account the EU administration, to make sure that it adheres to the highest standards of ethics and transparency, and that it is accountable. So we handle complaints. All of us as organizations, or every citizen or resident in the EU can come and lodge a complaint if they think that one of the EU actors, an EU agency, office, body, has done something wrong, be it in terms of fundamental rights. I think this is one of the main areas of work that is especially applicable given the topic of what we'll be speaking about today. So this is a big chunk of what we do, but it could be other areas. It could be access to documents, it could be transparency, it could be any irregularity. A citizen organization wrote to one of the institutions, they did not reply. So these are just highlights, examples of some of the things that we can help with or we are looking into. And so on the next slide, we can move immediately to two of the own initiative inquiries, two pieces of our work that you rightly identified are most pertinent, I think, for what we'll be speaking today. And one is our own initiative inquiry in the field of disability rights. This is a piece of work that we completed last year. It builds on a number of complaints that we received from civil society organizations, from some of the presenters, participants today. As already highlighted, this has been important topic, and it has not been solved. So all of these topics unfortunately remain. But we do hope that with our work and some of the questions that we're asking the Commission as being responsible for these funds and monitoring these funds, we are helping about the transparency and helping towards the general cause of some of these issues. So this is own initiative OI 2021. And you can, I'll just speak about several highlights, but of course, all of you can check the full decision, all of the contributions we have received about it. So you can just go to our website. Everything is there where if you want to know more to see the full extent of the decision. So what it is about the Ombudsman checking and inquiring into the Commission's role in ensuring that member states use European structural investment funds to promote independent living. What we did is we sent the Commission a series of questions, and we also received input contribution from civil society organizations and also from national and regional ombudsman offices. The European Ombudsman chairs what is called the European Network of Ombudsmen. So these are in Europe ombudsman offices who are, by their definition, fundamental rights bodies. And also in certain countries, they don't have a national office, so these would be regional ombudsmen. So we also ask them to make a contribution to our inquiry, because they're better placed to tell us what's happening on the ground in the member states. And there's a summary of their contributions also on our website if you want to look more into detail. The Ombudsman reminded the Commission that the rules governing these funds, of course, require that they are used in a way that is promoting the institutionalization, which is an important standard, fundamental rights standard. It also, the Ombudsman also reminded the Commission about the prohibition of discrimination on the grounds of disability under the UN Convention on the Rights of Persons with Disability and the EU Charter of Fundamental Rights. And we also highlighted the concerns, the recommendations, the guidance on this deinstitutionalization that is coming from the UNCRPD committee, from the review of the compliance of the EU with the standards under the UNCRPD. Next slide, please. And after meeting, hearing, speaking with the Commission and receiving these contributions from the national and regional ombudsmen, from civil society, we distilled a number of suggestions for improvement towards the European Commission. The list is long. You could see all of it in our decision. I have highlighted here just several of those. One of the important one is monitoring. The Ombudsman, on the basis of the inquiry, saw that monitoring could be indeed improved. So on the part of the Commission, the way it sources its information, the way it satisfies with itself as to what is happening, where the money goes, how it is spent on a member state level, it cannot be only that a beautifully written report comes from a member state. Independent sources of information also need to be taken into account, and when there are issues, those should be addressed. And this is the mandate of the Commission. This is their responsibility when they authorize the money flowing for these purposes. And the other important in this regard was the suggestion to improve and to make it easier for organizations representing persons with disabilities to participate in these monitoring activities. While the Commission maintains that it is ultimately member states who decide who is sitting on monitoring committees, of course, it is important that such organizations are represented, and we are assured that the Commission has issued guidance to its staff. So in relation to that, staff of the Commission should be encouraging all member states to include and to make it easier to include organizations representing persons with disabilities in these monitoring activities, and also in an appropriate role to include ombudsman institutions, which is also an important thing to consider and an important message to member states, because again, these are the actors who have first-hand knowledge as to what the problems are and what is happening on the ground. The other suggestion that I have highlighted here is that the Commission should update all of its guidance to staff who are dealing with the management of these funds. The Ombudsman also highlighted that certainly a more proactive approach to enforcement is necessary. So monitoring, yes, once problems are identified, what does the Commission do in terms of infringement proceedings, how quickly those are running. So there's a detailed suggestion for improvement there in our decision. And because the file was closed last year, we're already not only in the field of these ESI funds, but there are other funds in play, and also in what concerns financing activities related to the rights of persons with disabilities. And so the Ombudsman specifically addressed to the Commission her recommendation that also vigilance is needed for other funds as well. And most recently, it's indeed the Recovery and Resilience Funds, the Recovery and Resilience Facility, which we know already from some Ombudsman institutions that there are irregularities and the money is flowing not in the right direction also. So this is an important area to watch. And I will finish here regarding the highlights for this own initiative, and we can move to the next slide, and we can discuss also about the field of migration, where we also had an own initiative inquiry of the Ombudsman related to the funds used in the field of migration operations and migration management. So this is inquiry OI3 2022. It was completed this summer. And again, like for the other one, if you want to see the full extent of the decisions, all the suggestions for improvement we've addressed to the Commission, you can visit the website and check all the information there. But what it was about, so I will summarize it briefly. The inquiry was born out of the publicly available information and the serious concerns about the so-called multi-purpose reception and identification centers in Greece. This is the EU-funded migration facilities in Greece, in various islands. And the money was flowing through funds, both the Asylum Migration Integration Fund and the Internal Security Fund. The inquiry, of course, again included civil society consultation and input from civil society organizations. And the inquiry was very much concerned with the fact that many of these facilities, there was a problem in relation to the detention feel and like of them, meaning that while they were they were supposed to be for identification and for reception purposes, the way they were built, the way they're operating is like detention facilities in practice. And this is a very strong and evidenced information that came precisely from organizations working on the ground. And so the Ombudsman uses strong language in her decision regarding the fact that this should have been prevented even from the outset and should certainly be corrected as we speak. Next slide, please. And so I will move to, again, highlighting some of the suggested improvements that we distilled at the end of the inquiry. There is this task force on migration management in relation to the facilities. This is essentially a task force operating within the DG Home, which is aimed to facilitate the coordination of the migration management issues between the European Commission and the Greek authorities. And the Ombudsman found that there is a need to improve the transparency of this task force so that the public, organizations, citizens can be informed through its minutes and through its reports what is really happening, are problems being addressed, are there improvements. One of the major suggestions that the Ombudsman highlighted to the Commission was that some of the problems could have been evaded from the start if the Commission had carried a fundamental rights assessment of the centers. And for us, this was an important improvement that we address to the Commission, because it is clear that the current legal requirement for these concrete migration funds does not ask for fundamental rights assessments of the centers. But the Ombudsman really felt the need to highlight that this is important. This should be a practice and not an exceptional measure. And we are now in the follow-up stage of this inquiry. And the Commission has promised us that actually they will do this. But we are still asking and looking for the concrete information. We should be contacting them soon on when and how this is taking place. But we certainly think that this is a step in the right direction already to make the pledge that such assessments will take place, and that they will also be updated as activities in these centers continue. And many of the other suggestions for improvement were really about the transparency of how the Commission is monitoring, of how this task force is working. The Commission has certain assessments done by the local authorities, and so all of our recommendations are really about making all of this information and all of these documents public, so that we can all have access to them and see how things are happening there. So I will stop with these highlights in mind. I also wanted to speak about just two announcements. One, we have another inquiry that we closed this year. It's SI 6/2021, and this is about the RRF facility, the Resilience and Recovery Fund. So we issued the decision now in September, and there again, the Ombudsman is asking for further transparency measures. It is clear as a result of the inquiry that the Commission still needs to refine that, because in certain there are gaps as to where the money is flowing. Although there's been certain promises on the parts of member states and certain databases are in place, it is not clear that the Commission is fully capable at this stage, with information that is public, to really oversee and monitor where the money is flowing. So this is, if you're interested, you could check it out. And the other announcement I have is in relation to migration. We spoke about that this is a hot topic. Tomorrow in the afternoon takes place the annual conference on the European Network of Ombudsmen, and the session between 2:30 and 4 is on human rights approaches to migration. We have national ombudsman, the European Ombudsman, who will be speaking, so we'll be able to hear firsthand about their work on this topic. So it is between 2:30 and 4, and the link will be on the website of the European Ombudsman. So even if you didn't know about it or did not register in advance, you can just click and watch the event live. And this is all on my side. Thank you very much, and I look forward to the other presentations and the discussion.
Thank you very much, Valentina. Thank you. It was really very interesting, comprehensive, and you kept actually the time very well. Probably not only me, but some other participants, they have very much burning questions. But if you don't mind, we will go first to Tamás, and we'll be listening actually his presentation about the draft directive on the standards of equality bodies. And then after these two presentations, we will open the floor actually for questions. Valentina, please be prepared actually for questions, because there will be many. I'm just joking. Tamás, the floor is yours.
Thank you, Andor. Hello, everyone. My name is Tamás Kádár, and I work at EQUINET, which is the European Network of Equality Bodies based in Brussels. And, well, equality bodies are obviously one of those fundamental rights bodies that are in the title of this webinar. This is why I have been invited. So EQUINET has 48 statutory public bodies in our membership, covering 38 European countries, so going beyond the EU. The mandate of the equality bodies is largely based on the EU Equal Treatment Directives, so they cover the grounds of age, disability, religion or belief, sexual orientation, sex, and race or ethnic origin. But many member states actually decided to go beyond what's in the EU directives, and they cover further grounds or further fields of discrimination. So equality bodies have quite a wide mandate. I think what they might be best known for is that they have to provide, by EU law, they all have to be able to provide assistance, independent assistance to victims, which is through casework, strategic litigation, amicus curiae, intervention support. But they also do promotional work. They work with duty bearers. They provide guidance to them. They also do awareness raising work. They also work on establishing a knowledge base on discrimination and equality. So they do research and data collection. And of course, they also make recommendations and give policy advice to the legislators and policymakers. This is what they do by and large. And just by way of a very short introduction on why they are relevant for the topic of EU funds and EU funding, we have worked on that actually last year. EQUINET published a report on equality bodies and the European structural and investment funds, which is also has the subtitle Realizing the Potential for Change. As the title suggests, we wanted to delve into this topic because we think that equality bodies can play an important role, and there is a huge potential given the money involved and the dimension of the projects that are funded by EU money. And basically one of the or the starting point, I would say, is that member states are required under the Common Provisions Regulation for shared management funds to establish a comprehensive partnership, and the partners shall be involved in the planning, implementing, and evaluating the structural investment funds, including through participation in monitoring committees. And this partnership is defined as including equality bodies, which the regulation calls bodies responsible for promoting social inclusion, fundamental rights, rights of persons with disabilities, gender equality, and non-discrimination. So again, it's very interesting and important here to note that equality bodies shall be partners, shall be part of this partnership, and they therefore should have a role in the planning, preparation, implementation, and evaluation of the EU funds. And there is an important rationale for equality bodies to be involved, which again is evident because of the potential of the structural investment funds to influence social and economic development and policy systems, and also the significant focus on equality and human rights within this potential. There are very important enabling conditions that are relevant for all the funds that relate specifically to equality and human rights, relating to the Charter of Fundamental Rights and to the UN CRPD. There are also thematic enabling conditions to have gender equality, action plans, strategic policy framework for social inclusion and poverty reduction, and also a Roma inclusion strategic framework. And also, of course, the respect for the fundamental rights and compliance with the Charter of Fundamental Rights is a horizontal principle, as is the equality between women and men and gender mainstreaming, and also non-discrimination across the full spectrum of grounds is also there. So it is on this basis that equality bodies engage. And what we have seen is that they have mostly been involved through monitoring processes and membership of various monitoring committees. And they do face some important barriers relating to the technical nature of the field, which is something new to many of the equality bodies, the resources and capacity, which is limited, and also, I would have to say, the political will from the side of the policymakers and the managing authorities to actually want to involve equality bodies and have a fundamental rights lens to the activities. Besides the monitoring, what I think is also interesting that some of our members are also engaging in submitting complaints through dedicated complaint mechanisms under the funds, or just simply generally through the courts or also the European Commission. Now, with all this in mind, I think it's also important to see, and as I mentioned, that resources is a major obstacle. I think it's important to see that equality bodies across the EU exist in many shape and form. And this is partly because the standards for equality bodies are very limited in the existing EU directives. They only require that every member state and also accession countries designate an equality body, and that it should provide independent assistance, be able to do independent surveys and reports, and make recommendations. But it doesn't go further than that. So we realize that, and EQUINET has been calling for sort of more detailed and more comprehensive standards since at least 2016. And then there was a European Commission recommendation, which was issued in 2018. But that's a recommendation, so it's a soft law instrument. And the European Commission itself noted that it hasn't really been implemented properly in 2021. So after 3 years, when they looked at it, they realized that this is just not working. So last December in 2022, they came out with 2 proposals for directives on standards for equality bodies. And the legislative process is ongoing, but we are hoping that the 2 directives can be adopted early next year. And these standards would regulate the mandate of equality bodies to make sure that all grounds and fields of discrimination are covered, their independence, their resources, their capacity to work on prevention, promotion, and awareness raising, their work on assistance to victims, which also encompasses the alternative dispute resolution, opinions and decisions, and litigation powers. It would also address the accessibility of equality bodies, making sure that everyone can access them. It would also talk about cooperation and consultation. And here I wanted to mention that when the European Commission proposal talks about cooperation, it specifically mentions cooperation with authorities managing union funds. It would also, these standards would also address data collection and access to equality data and reports. And they would also address how these standards would be monitored by the European Commission. And as a reminder, the explanatory memorandum of these directive proposals refer to the Common Provisions Regulations. And they do make this statement that among the many other things that equality bodies do, they also play a role in sort of overseeing and being a partner in EU funding, in the management of EU funds, through being involved in the partnership and playing a role in the preparation, planning, implementation, and evaluation of them. So this is, I think, where we are. I guess that the conclusion is that this is a field which is growing in its importance. I think many equality bodies see the importance of this work. Several of them have started working on it, but they are also facing some major difficulties, ranging from the lack of political will to actually involve them in the process, through resources and understanding, because you would need dedicated expert colleagues to follow this field. And of course, there are also some concerns around the independence of equality bodies, how far they can be involved, or how far such fundamental rights bodies like equality bodies should rather be overseeing the process rather than being involved in the process. Should they be rather overseeing the process from the outside? Thank you very much. This is from my side.
Thank you very much, Tamás. It was great. I would like to open the floor for very much the burning questions. So dear participants, please raise your hand, and you can put questions also in the chat. If you have some burning questions, you will have time actually to ask questions also actually in the facilitated discussions a bit later. But if you have very burning questions before you forget, just please go ahead. We have a few minutes actually to ask questions from Valentina and Tamás. Is there anybody who wants to ask questions?
Michelle.
Yes.
Michelle.
Yes. Hello.
Sorry.
Good afternoon, everyone. I'm Michelle Mila van Burg from the Netherlands and a long-standing Roma advocate for almost 20 years. And I have a burning question in the sense that how would it be possible to make sure that to implement the role, for example, of this case, Roma grassroots, and also to improve or to start with a decision-making role for Roma in this whole context? So that is my burning question, because I've asked this question many times, not to you, but to other people and to organizations. And still what I see, that there are still too much barriers for Roma to participate. And it's about Roma issues and Roma rights issues. So hence my question, how could we improve, or at least start with, to create influence in the decision-maker role at an equal level in this case?
Thank you, Michelle.
Thank you.
Thank you. Thank you very much, Michelle. Adam, I see your hand. Please be short.
I will try. Do you hear me?
Yes.
So my question is exactly the same as I had in the chat. So basically, for the example from Poland, from which I am, unfortunately, for the previous perspective and the current perspective, the situation is that even though we're we use the highest proportion of EU funds in the whole EU states, still the Human Rights Commissioner, which is the Polish Ombudsman, is literally excluded from all of, I would say, any monitoring committees. And we have 16 regional committees plus 6 standard macro regional committees and national committees, and also other additional committees. And still, we have a lot of discussions which go on human rights. Exactly, quite frankly, these are most of the discussions that go on monitoring, many of the monitoring committees. And still, I don't also recall any kinds of EU funds going to the Human Rights Commissioner on the monitoring, for example. And so basically, I would say that the EU funds exclude the constitutional body, which was set in stone by the to monitor those kinds of situations. And these are a number of ones, because of course Poland had also complaints on the misusage of funds, and the CRPD committee even stated that in its report that there is misusage of funds, and still nothing has been done. So my question is, how is that possible in line with the EU law?
Yeah, thank you very much.
And what can be done?
Yeah, I've seen in the chat, Rita, if I understand well, that you have also questions, but you are okay actually to raise your questions in the discussion, in the facilitated discussion. Is it true, Rita?
Yes, no problem.
Okay, then we can wait for that. Valentina, Tamás, do you have a quick response to these 2 questions? Valentina, maybe we can start with you.
Thank you. Maybe to the second point Adam made, because I think it really relates to something we were working on and that I mentioned earlier, is that indeed it is our opinion, having done these inquiries in both fields actually, and generally as regards funds, it could be any type of funds, and how the Commission is ensuring that fundamental rights are respected in funding activities. So indeed it is our view that we should have on all these monitoring committees or similar entities, we should encourage and we should make sure that there's an easy, pertinent, adequate representation by the relative organizations that represent the interests of the concrete people that the funds are about, and of the fundamental rights bodies. In our case, we are most familiar with Ombudsman. These are our colleagues in the member states. So for us, this is crucial, and we are spelling it out in our decisions. I think I mentioned about one of the inquiries that we got alerted, we got informed that there's this document issued by the Commission towards its staff internally that says that staff members should be encouraging and should be suggesting to member states to include ombudsman institutions in an appropriate role in these monitoring committees. But which I think is a great starting point. But as is being said, of course, this is an uphill battle, and in certain circumstances, in certain member states, this should be taken forward also by all of us and advocate for it. It's not a given that it is happening, although the Commission is asking for it or is encouraging member states to be doing it. So for us, certainly, we're taking this in mind. We keep looking into it, but it's a difficult question, because if the member state does not want to do it, indeed, what's the solution for them?
Yes, and if you don't mind, Valentina, we will come back to this question in a bit more general perspective, in that sense that exactly how to force or reinforce, let's say, actually your recommendations, instructions, either to the Commission or member states, because many of the colleagues who are sitting here today, they will ask most probably the question, but in particular, I will ask this question. So what to do next? Because we have been facing actually this situation for many years, that recommendations are coming from you and it's not implemented. So what to do next? But we will come back to this, because this is one of the most important and, let's say, very burning question actually for this seminar. Tamás, the floor is yours if you want to respond to these two questions.
Yeah, thank you. Just very briefly, of course, the Polish Commissioner for Human Rights is also a member of EQUINET, as is the National Council for Combating Discrimination. Prabha will also speak later in representing the Romanian equality body. So when we were devising this report that I referred to and that I also sent in the chat, what we found is, as I already mentioned, there are several barriers. I already talked about resources, lack of expertise. I also talked about the potential issues about the independence and how equality bodies, walk quite a fine line there, and they don't want to be seen as making the decisions or contributing to making decisions, because that's not really their role. And
can I stop you? Sorry, can I stop you for a second? Yeah, just because the question would be that, let's say, if EQUINET would propose a kind of suggestions, recommendations to any member state, saying that, guys, you have to involve actually the equal treatment body in the monitoring committee or any other, let's say, framework, then what's happening? Because we understand actually the barriers, but can we see a little bit actually the other side of these questions? What's happening when you are suggesting actually to do something and member states, they are not following it?
Yes, I was gonna get there actually, Andor.
Sorry, I'm so sorry.
No, that's fine. So I think that of course, we are making and underlining the recommendation to involve equality bodies in this report, among others. But I have my doubts about the might of such EQUINET recommendations if actual hard law is not enough to get equality bodies involved. We can make all the recommendations we want, but it's actually in the regulation, in the EU regulation, which is directly applicable and directly effective. So if that's not enough, then I don't know what should be enough. So I think the most important point would be probably to actually monitor that, and if there is something missing, if the regulation is not properly implemented, to start infringement procedures just on that basis. But even I wanted to make just a further point that I think that we also have to differentiate between meaningful involvement and not so meaningful involvement. And I think that resources and technical expertise is sometimes lacking, so that could also contribute to equality bodies not always being able to meaningfully contribute to all the different monitoring committees. But also there is not so much receptiveness from the side of monitoring committees to meaningfully involve equality bodies. If they are there, they are sometimes, what we heard is, they are not really listened to. They don't really have a voice that can really bring home what should be taken into account from an equality perspective, and that's definitely a problem. So even if they are there, I would say they cannot really reach the desired effect quite often, which is a further problem.
Yeah, thank you very much, Valentina. Tamás, just one sentence from both of you actually to respond to Michelle, what she said. So Roma organizations, they are claiming actually for better participation in this procedure. Like, I don't know, participation in a monitoring committee, monitoring procedures and everything. Can you do something around these questions? And of course, it concerns not only Roma organizations, but others as well. But now, if you are broadening the scope, not about the fundamental rights bodies, but also actually organizations who are representing the community, can you do something actually in discussions, Valentina?
Yes, on our side, as you said, it's a broader question. Of course, any in funds or in this type of issues, any organizations representing the people for whom the funding should be going, or for whom the EU activity should be going, should be on these monitoring boards, should have a meaningful participation. So there's no doubt about it. The question is, in practice, how is this happening? Is it not happening? So I would say on our side, we're clearly recommending this to the Commission. I know that our colleagues at the national level, the Ombudsman, the human rights organizations, are recommending this at the national level. And so I think we will just, on our side, it is clear that this is not the end of the story. We will continue to monitor and engage with the Commission on these matters. So there will be follow-up investigations, follow-up inquiries. And I think when such organizations act or lodge complaints or engage also with our colleagues at the national level, I think this is where, in these, especially in these funds that are managed together, Commission and member state, this is the way to. So when a complaint comes to us, we do our part at the EU level. We ask the questions to the Commission. We make the certain recommendations, and our colleagues are doing the same at the national level. So on our side, given our mandate, this is what we are doing. We will continue to do.
Yeah, Tamás, one sentence on this.
One sentence is in the very same article in the Common Provisions Regulations, it is foreseen also that civil society and non-governmental organizations should be part of the partnership and the monitoring committees. If they are not, that's a problem. Or if their involvement is not meaningful, as I also mentioned, that's also a problem. So I think this is something that has to be tackled. And equality bodies have many equality bodies have structured cooperation with NGOs. So I think that they can also mutually strengthen each other and help each other to get into these processes and be able to follow these processes.
Okay, perfect. Thank you very much. We will come back to this whole topic in the discussion, because actually, as you mentioned, actually we need to figure out actually how much some further legal tools can be used actually to make some more pressure. But let's continue the discussion, because I think we will have some very interesting presentations. If you don't mind, we would continue actually with Marton Ravid from the Fundamental Rights Agency. Marton will be speaking actually about the pilot, what the FRA is doing on working with human rights institutions, and also actually about the upcoming report. Marton, the floor is yours. Marton, are you around?
Yes, I'm here. Can you see my screen?
Yes, now we see you.
Yeah. So thank you for the invitation. I'm very happy to be here on behalf of the Fundamental Rights Agency, together with my colleague Robert Jan Ull. And I will tell you what the Fundamental Rights Agency is doing in this field, basically to talk about three topics in 8 minutes. One is, what is our position on this new directive that Tamás mentioned. Talk a bit about an upcoming report that FRA is publishing in mid-December, and finally to talk briefly about a project in this field. Concerning our position in this new directive, of course, we support very much to create minimum standards for equality bodies and to empower them. And I think it doesn't come as a surprise that FRA would be happy to contribute to indicators and to provide data on how this new directive will be implemented, in particular concerning the resources, independence, effectiveness, and the changing mandate of equality bodies. As we know, the Commission will report on the implementation of this directive, and the Fundamental Rights Agency would be very happy to provide input for this role. Next, a few words about our upcoming report, which is precisely on the topic of today, namely the role of national bodies with a human rights remit in monitoring the fundamental rights compliance of EU funds. So this report will be published mid-December in an event called Charter Exchange, to which you are all invited, and we are already also very grateful for all the contributions many of you had to this report in different consultations. We had actually a long research leading up to this report on EU and national level, involving the countries that you can see on the screen. And I will not go into the details of this report, which will be probably longer than 70 pages, but highlight some key findings, which are actually very much in line with what we heard from the European Ombudsman Office and EQUINET. One is that there is really a room to develop participation of national human rights bodies, especially at the early stages when drafting the partnership agreement and the programming phase. Also, contribution to the monitoring committees and the quality of participation is also very important. And as well in the last evaluation phase as well. We also, our research also found that there is a lack of capacity on the charter of the relevant national authorities, and there are also insufficient resources of equality bodies and national human rights institutions to deal with such an additional task. So of course they need additional resource to deal with this issue. And we also noted that civil society would also need more capacity to meaningfully be involved in these questions. And one more area which we haven't discussed so far are the complaints mechanisms, where we believe that their transparency could be further improved, also their accessibility and how they work. We have some specific recommendations how they could be further improved. So we have FRA opinions, which are pretty much in line with the key findings. I think I will not go very much into the details of the opinions, which are, I will rather move on to key takeaways we have for national human rights institutions and equality bodies. First is that they do have an expertise that is very relevant and should be used in monitoring EU funds, in particular when determining the selection criteria for EU funded projects. So I think this is one area where equality bodies and national human rights institutions should be involved. They have often the relevant data and they could meaningfully be involved in the work of monitoring committees. Maybe one more area to include in participation is the performance reviews, where equality bodies and national human rights institutions could be involved. Let's move on to capacity building, where the training of officials and also the beneficiaries of EU funds could be implemented or contributed by the national human rights bodies and equality bodies. They could also develop guiding materials and draw attention to the existing law standards, both soft and hard law. Finally, for complaints mechanisms, they also have an important role to train staff of managing authorities how to deal with complaints, and they could also be a points of reference for civil society organizations and contribute to the effective and accessible complaint mechanisms. So finally, how to do all these nice recommendations. So I will give you the example of a concrete project that we are doing. which is precisely partly in relation to piloting how this could work in reality. This is an ongoing project taking place between 2022 and 2024. Our expertise partner is the European Network for National Human Rights Institutions, ENRI, and we work in these 7 countries: Bulgaria, Croatia, Cyprus, Latvia, Poland, and Slovakia and Slovenia. Basically, there are 3 axes. One X is the promotion and application of the EU Charter of Fundamental Rights. The second is on rule of law monitoring. And the last one, which we are talking about now, is the monitoring of EU funds. And again, I will not go into the details, but basically the national human rights organizations, we are working in this field. They are reflecting on their own role. So they produce an analytical paper, how they see the context, their own national context and their possible contribution. They are also developing a guidance on how the role of different stakeholders in applying this new obligatory charter conditionality. And they also do capacity building, which of course varies from country to country. It can be for managing authorities, for judges, for civil society. But we also wanted to mention that something is happening in this field, which is hopefully forward-looking. So thank you for your attention, and we are looking forward to discussing further details in the discussion.
Thank you, Martin. I do really appreciate that you were very, very short and concise. At the same time, you are not escaping actually from the questions, because it was a very comprehensive presentation, and there are lots of details, but probably we need to a little bit discuss more. For example, just to give you an example, my understanding is that the FRA will be working actually on a guidance on the charter. Is it true, Martin?
Well, we have a lot of charter-related tools, but concerning EU funds, we have a report coming out. But a specific guidance or checklist we are not producing. But I also invite my colleague Robert Janul if you to specify the plans. Yeah.
Sure. Yes. So, André, you meant whether we were developing guidance on this topic specifically for. Yes, so that's included in the report, basically, right? So the takeaways for equality bodies and NHRIs will be included in the report. So it has to do with the fact that our opinions, which are recommendations essentially, are generally directed at the member states and the Commission, and we cannot obviously we can only make suggestions what equality bodies and NHRIs can do. So those are called takeaways, but they're integrated into the report, and Martin just briefly touched on them, but they will be there. Yeah. Mm-hmm.
So basically, if I understand well, this is just for my brain. So sorry for asking it again. So basically, this guidance is already will be included in the report, if I understand well. So, right?
Yes, that's right. Yeah, exactly.
Okay. Mm-hmm. Perfect. Thank you very much. So, just to avoid a misunderstanding that it will come after the report. Okay, perfect. Still, there will be some questions, but let's move forward. And I see that there are questions actually in the chat. For example, Adam, you raised some questions and recommendations. We will come back to this, Adam, if you don't mind, actually in the discussion where we will be opening the floor for more discussion. So the next presentation will come from Csaba Asztalos from Romania, the National Council for Combating Discrimination. And we asked Csaba to talk actually about the ways to reinforce the capacities of equal treatment bodies at the national level. As Tamás mentioned, actually, this is one of the most important barriers. So let's see what can be done or how the Romanian authorities, they are looking at this question. Csaba, the floor is yours.
Hello. First of all, thank you for inviting me for this meeting on behalf of the National Council for Combating Discrimination. And I would like to share with you our experience on this field of being involved in monitorization of the how in the access for the structural funds, how are implemented or respected the human rights issues in generally, and of course the principle of equality and non-discrimination. Our experience says that an equality body or a human rights institution cannot be everywhere every time. That we thought that it's important for those authorities who are managing the structurals and investment funds, European structurals and investment funds, to develop their own resources on the field of human rights and non-discrimination. And 9 years ago, we implemented a program which was financed by European Union to train civil servants from the authorities involved in the management and control of the European structural and investment funds, from the management authorities, intermediate bodies, the certification and payment authority, the audit authority at the all relevant levels in the management of dimension related to anti-discrimination, equal opportunities, and the right of persons with disabilities. The training was implemented in 3 modules during 1 year, and around 75% of the civil servants which were involved in this process, in these activities, were trained, and mainly on equality and non-discrimination, the right of the Roma minority, the equality between men and women, and the right of persons with disabilities. That's were the main topics on the training. In the same time, the Council was invited to appoint members in the monitoring committees of each operational program on the financial period of 2014 and 2020. And likewise, the Council was part on the coordination committee for the management of the partnership agreement between 2021 and 2027. That means that we were involved also in the preparation of the new financial period. And as the result of the approval of the partnership agreement, the Council is now part of the committee for monitoring the fulfillment of favorable conditions, being responsible for these conditions. That means that's an effective application and implementation of the Charter of Fundamental Rights of the EU, a condition otherwise which was fulfilled by the Romanian government. In order to fulfill this and in order to monitor this condition, was established the Committee on the Charter of Fundamental Rights of the European Union, which includes representatives of each management authority for each program following the partnership agreement 2021-2027. That means the Ministry of Investments of European Projects, the Ombudsman, the National Council for Combating Discrimination, the National Authority for Equal Opportunities between men and women, and we have a contact point for the implementation of the UN Convention of the Rights of Persons with Disabilities, and we have also a contact point for Roma as a permanent, they are permanent observers of this committee. What is doing this committee? That coordinates the activity of the management authorities in handling complaints and controlling projects in terms of compliance with the EU fundamental rights, receive information regarding any contradictions or non-compliance with the fundamental rights of Charter regarding the documents developed and the actions undertaken within the management authorities, provides advice and recommendations regarding compliance with the Charter within the management authorities' complaints management and control process, also providing assistance to the management authorities in handling complaints, as well as guidancing on the control systems. Also provides consultancy regarding cases of non-compliance with the Charter arising at any stage of the EU funds programming and management process and resulting from control procedures or reported by any person or organizations. Also, we recommend actions to investigate and or apply corrective measures to remedy cases of non-compliance with the Charter arising at any stage of the EU funds programming and management process. And we also have a report that annually informs through a report the Committee for the Coordination and Management of Partnership Agreement on the effective applications and implementation of the Charter of the Fundamental Rights of EU and the maintenance of compliance with the related horizontal favorable conditions. In the same time and this moment, the Council also participates as an observer member in all operational program monitoring committees. Let's say that we are, as an equality body, we are a law enforcement agency, that we have the power to start ex officio procedures in case of discrimination. Also, we receive complaints and we have the power to investigate cases, and we have the power to apply sanctions in discrimination cases, that we could establish fines. We can apply fines. In Romania, our experience says that as the authorities who are managing this issue, they were interested and they invited us from the beginning to be present in the whole process of managing this field. And they were very open to receive proposals, comments, or expertise from our side. That it was a constructive approach from their side, and otherwise they need us. Of course, our challenge is it's on the field of that having new competencies. We need resources, mainly human resources, to have the capabilities to offer these services for relevant institutions in Romania. But our experience is a positive one, that we have a good partnership with these institutions, and they are hearing us and they accept our proposals in this field. I think that it's important to continue with the actions and programs which it's ensuring for these authorities own capabilities, or a minimum standard of capabilities, own resources, minimum resources to handle this issue. They need to introducing in their institutional culture these values in order to implement in this process the human rights issues. That's our experience.
Thank you very much, Csaba. Thank you. I think we will come back to this Romanian example in the discussion from the point of view that some of the colleagues who will come now, they will talk actually about the complaints or different issues, what's happening actually with the EU funds, among others, in Romania. So maybe actually it would be important actually to see questions like complaints have been already submitted actually about the use of EU funds in Romania, and actually let's say how you can or somebody else can respond. So I think that would be a great opportunity to invite Steven and Inez to make the presentation actually about their work and about their experiences about the involvement of fundamental rights bodies in the complaints mechanism, because also it was mentioned earlier that by the FRA and also actually by the European Ombudsman Office, that one thing about the involvement of the fundamental rights bodies, but the other thing is, which we need to discuss, and I think one of the most important questions for today is what's happening with the complaints. Stephen, Ines, who will start?
I think I'm going to start and then I'm going to hand over to Ines. Thank you very much, Andor, for the invitation to speak again. Firstly, apologies, I'm a bit bedraggled. I started training at 6 a.m. in Uganda this morning, and so I'm still going. So please bear with me in the next few minutes. Second thing I want to say is that I see this event as a mark of our success of 10 years of advocacy. A lot of what you're going to hear over the next few minutes, both from Ines and I, are that we are incredibly frustrated at the lack of enforcement of Charter standards of international human rights law related to persons with disabilities. And in fact, it has taken us almost a decade just to get many of the institutions and you here around these tables. So I see this as a crucially important step forward. Tomáš Kádár, he made an important point. There remains in our field, which relates to disability rights, an incredible lack of political will to make real change to promote deinstitutionalization for persons with disabilities. Indeed, I don't think, and as I'm going to talk about, I don't think this is about a lack of legal tools, either of member states or of the European Commission to enforce the law. Indeed, I think that this is something else. I think that this is a real cynicism on the part of many decision makers in the control and management of funds, and particularly the European structural and investment funds that we have seen repeatedly now for a decade. Many of you have helped already to expose these issues. We are frustrated that we are still not seeing the enforcement side. So one thing that I want to argue for in this short presentation is that we go beyond those recommendations. I know that EQUINET is also thinking about this at the event next week that you've mentioned, Tomáš. I know that others of you are as well. We need a comprehensive strategy, not just to advocate, but in my view, to litigate and to really get a few of the key principles established as a matter of European jurisprudence and not just a question of European law. So I'm going to share my screen. I'm not going to bore you. I'm going to try and go quite fast and then give over to Ines as well. So can you see my screen? Yes? Okay, great. So non-discrimination law. I think that in our field in disability rights, we don't have the strongest legal protections written into the law, except anti-discrimination law in the European Union has been going through a progressive development over the last 2 decades that certainly give us some important legal concepts to rely on. The Employment Directive prohibits discrimination on a direct basis against persons with disabilities and also indirectly. So we've got legal tools here that we can use in other areas. It does give a defense to discrimination. Of course, as you know, there must be objective justifications for treatment that is differential, and it must be aimed at achieving a legitimate aim. Now, is institutionalization, that's my question to you, is it pursuing a legitimate aim? I think that this question really is not being made out, frankly, on the jurisprudence as yet. And as you know, the Charter of Fundamental Rights also gives us some important legal tools. So here, I think we need to take the debate a step further. We need to be able to make very clearly the argument that institutionalization of persons with disabilities on the basis of disabilities is in fact a prohibited form of discrimination by virtue of both the combination of European Union law, but I also have to say in combination with international human rights law. And indeed, it's crucially important to understand what the Convention on the Rights of Persons with Disabilities does as a matter of the EU's confirmation of it in 2010. Indeed, it gives the same status to the CRPD giving within European Union law as the treaties. Indeed, it is a standard through which and by which even fundamental rights provisions should be considered. Remember, the Charter of Fundamental Rights is the base. It is not as high as we can go. And indeed, the concept of discrimination on the basis of disability, I think, can be better understood when we look at Article 2 of the Convention on the Rights of People with Disabilities. Any distinction, exclusion, restriction on the basis of disability which has the purpose or effect of impairing or nullifying the recognition, enjoyment, or exercise on an equal basis with others of all human rights. Okay, we're not here merely talking about the right to care or support, which is often what these discussions are framed around. We're not even talking here about the right to reasonable accommodations or the integration of persons with disabilities into the community. No, we're talking here about any action that undermines or nullifies the human rights of persons with disabilities. So here, my central argument, and ours has often been, that institutionalization is discrimination. I have to say that many equality bodies and national human rights institutions still have a skeptical view on this perspective, but we need to move forward. So institutionalization is indeed a prohibited form of discrimination under international law, and it is important that European Union jurisprudence catches up. That's by virtue not only of Articles 5 and 19 of the Convention on the Rights of People with Disabilities, but also, and I think this is crucial to understand, the authoritative interpretations of that treaty by the Committee on the Rights of Persons with Disabilities. Here we will share all of this later, and I'm not going to read it all out. But I think it's absolutely critical in the work of equality bodies not to restrict themselves purely to imperfect national legislation, which doesn't necessarily cover all of the forms of direct and indirect discrimination faced by persons with disabilities, nor even EU law, which is necessarily circumscribed. It's absolutely critical to have a strong awareness of these normative bases coming from international law. And we still see that very rarely are these bases used by national equality bodies and human rights institutions. So let's just be clear. What is an institution? Do you even recognize one when you see them? It's not about its size, location, name, or legal status. You must be able to, and we argue for this, including for policymakers, conduct a far more complex rights-based assessment of programs that are coming before national bodies and also European Union as well. Does the project at question promote or inhibit independent living and inclusion in the community? That's the real question. Not just does it comply with the basics of the common provisions regulations, but does it promote or inhibit independent living? That's the right at stake here. And I would strongly encourage everyone to review the CRPD Committee's recent guidelines on deinstitutionalization in emergencies. Adam has mentioned it. EQUINET's got a session on this next week, and I think it's very important to understand how to identify institutions. There's been a lot of debate about whether certain numbers of people is acceptable, whether certain arrangements to separate housing or not are acceptable. The guidelines on deinstitutionalization really do provide the most authoritative and comprehensive analysis of this, and yet we still see that member states go for a number of models, including smaller group homes or the renovation of large institutions, which are clearly prohibited under international law. Now, I just flagged this toolkit that was developed both by Bridge EU, so Andor, thank you very much for this, along with some of us, which goes into far greater detail, I have to say, about how to assess EU funds in light of disability rights and in terms of the concept of deinstitutionalization that was previously mentioned. It goes even further to talk about what sort of things do you need to be watching out in calls for proposals and projects. What do you need to be collecting information on to come to a determination as to whether this scheme promotes or indeed inhibits the right to independent living for persons with disabilities. I'm going to come to a very short final slide here before I hand over to Ines, if I may. So what roles do we think equalities need to play? Because honestly, we haven't had a lot of success so far. We think that there needs to be, as some of you have already talked about, proactive and ongoing assessment of national deinstitutionalization strategies, not just the programming, but the DI strategies themselves at the national level. And to gain an understanding of whether or not those are in line with international law, it is crucially important that you refer again to the concluding observations of the Committee on the Rights of Persons with Disabilities. It has reviewed almost every, I think, European Union member state, including under Articles 5 and 19 of the Convention. And that can be your starting point to get an understanding as to whether the member state is indeed going in the correct direction or not. So we encourage you to look at that. The inquiry that was conducted by the CRPD Committee against Hungary clearly found that European Union funds was being used to propagate a system of large-scale institutionalization and discrimination of persons with disabilities. It's there in black and white, and that is a semi-judicial outcome from that United Nations treaty body. So it is incredibly important, I think, to review that. The EU itself has refused to ratify the optional protocol to the CRPD. It does not want individual complaints against it at this stage. Collectively, national human rights institutions and equality bodies should be calling on the EU to ratify the optional protocol, because this will enhance the ability for European civil society to complain where the European Commission itself fails to take action where we know that these problems happen. You've already spoken about ex officio and other thematic investigations, but here's also something for all equality bodies in particular to consider, and particularly those of you that hold judicial or semi-judicial roles in the enforcement of anti-discrimination law. I mentioned at the top here that the jurisprudence at the European level is still weak on identifying institutionalization of persons with disabilities itself as a prohibited form of discrimination. Many of your authorities will have the ability to make preliminary reference requests to the Court of Justice of the European Union to get an authoritative interpretation from that Court of Justice on whether or not certain programs and schemes do actually conflict with both the European and international equality and human rights standards. We don't have that jurisprudence now. And honestly, with all of the advocacy that we have done in recent years, you'll hear more from Ines about this shortly, we need to go beyond the advocacy. We do now need binding precedent to hold accountable duty bearers, including the European Commission and European Union member states. So with that very rapid presentation, could I just hand over also to Ines, please? Ines.
Yes, thanks, Stephen. And you did sound quite awake. I'll talk a little bit about our more practical experience and how we've used the national, equality bodies and basically our experience in this respect. So, Stephen, you can go on to the next slide. So as a European organization, obviously we don't, so I'm speaking also on behalf of the European Network on Independent Living, I should have said that. So we are an EU level organization, so we cannot make complaints, at the national level. This would be for our members to do. But we certainly do use the reports and the opinions of the national human rights institutions when making complaints to the European Commission against the managing authorities. So I've pulled out a couple of examples here. And just to show you how the European Commission is treating this information. So in Romania, it was about the use of ERDF and the building of sheltered housing units and daycare centers. And the complaint related to something that was going to be built in the future. So, we wanted to stop that from happening, obviously. And so we've used the information, the report from the National Preventative Mechanism and the Monitoring Council, which classified these types of shelter housing units as places where persons with disability are deprived of their liberty, and these places were subject to monitoring. So these kinds of places were, clearly places of detention. And in similar places to the ones that were going to be built, the MPM documented all sorts of abuse against beneficiaries, including forced work, forced shaving, other assaults, insults, and theft. So we have used this, to say that we have a very strong, besides, the CRPD and the general comments, there is a very strong indication that what is going to be built, is not going to be great. But still, the European Commission found that there is absolutely no evidence for us to say that something that doesn't exist yet, that is going to be built in the future, is going to be violating anybody's rights, So it was just a very kind of, basically, we are kind of making things up that possibly something is going to be wrong in these places. So you can see here there are, and obviously, there's a lot of reports from human rights organizations, but we generally use the national equality bodies, ombudsman reports, because they should hold kind of, a higher, well, they have a certain position in the country, right? They have a certain role. They're sort of given this role by the parliament or whoever, so they should hold even more weight towards the commission. So this was an example from Romania. Then in Austria, it was about
Ines,
yeah.
Can I interrupt you for a second? Would it be possible that we, of course, we can discuss all of these examples, but if we do it now, then maybe actually we will not have enough time actually for the presentation from the Polish Ombudsman. So shall we do it actually in this way that you're mentioning these examples, of course, very briefly, but for the details, maybe we can go back in the facilitated discussion. Sure?
Yeah,
Thanks.
sure. I'll shorten it. So we have the example of the Rural Development Fund, where again we've used the information from the Austrian Ombudsman Board, saying that basically in Austria or in Upper Austria, disabled people could not choose where they live, and most of the services were institutional. Again, the Commission did not take that into account and found that there was absolutely no evidence that Austria was not acting in line with the CRPD and the Charter, and what they were doing was in line with the deinstitutionalization strategy. Similarly in Poland, and we'll hear from the Polish Commissioner, we've received a letter of support to our complaint, saying that Poland does not have a deinstitutionalization strategy in place. And here the Commission took note of this and shared our concerns, but decided that there was another place for this discussion. Basically, it should not be in relation to our complaint. And in all of these complaints, the Commission found no violation of the Charter or the CRPD in relation to the building of segregated facilities. Next slide. I also wanted to mention the complaint we have done to the European Ombudsman. And this is something we can do as a European organization and have been doing. And this was in relation to three things, actually: to the building of several, to more institutions, not just one in Hungary, Portugal, but also about the legal service opinion. And here the European Ombudsman found several, deficiencies or shortcomings. But for example, it did not say anything about the legal service opinion simply because the Commission preferred not to dwell on that because at that time we had a case against Bulgaria. And the Ombudsman found that the European Commission was doing something, was taking some steps to improve things. So the inquiry, while finding some shortcomings and making recommendations, was closed with that. So my question here, and I wanted to ask this, Valentina, this is, what kind of threshold is there for maladministration by the European Commission, and what would it take for something to amount to maladministration? Because the European Ombudsman does have a lot of faith in the European Commission in improving things, and the Commission may improve things procedurally, but the outcome may still be, bad, let's say. And go to the next slide, Stephen. So just a couple of points on what is missing. Stephen talked about, what role NHRIs could play, and I'll talk a little bit about what is missing. So this was already mentioned several times today. There's definitely more capacity to look at all of this, all of the funding instruments, to assess complaints, to assess complaints, to carry out investigations. But also, they can, with all the capacity, if there is no real understanding of this, what Stephen was talking about, of, what is an institution, what are the requirements under the CRPD, and how the funds should be used as well. Then again, we cannot expect, expect that the human rights institutions are going to uncover really all the human rights violations. So I think this is the main, this is actually the main point. And it's linked to then who is also training the national human rights institutions, because we have heard something about that, but it would be very important that, disabled people's organizations or organizations representing other user groups or other human rights, groups, and including survivors of institutionalization, are involved in the training and monitoring and how to monitor EU funds used. I also, obviously there is here a role for the European Commission to recognize NHRIs as an authority when examining complaints. And this is maybe with these standards, this is going to improve. Who knows? And finally, two final points. Perhaps there is a role for, even with the European Ombudsman's inquiries and, the complaints, the Commission tends to ignore this in any case, at least, in our opinion. So there is really, there is no follow-up again by, I don't know, nobody's actually calling the European Commission to account on that. So perhaps there is a role here for the Parliament, maybe. And the final point, I think there is really a need to recognize the severity of human rights abuses on all sides, and for more coordination between all the different at all the different levels, between national human rights institutions at EU level, for this topic of the misuse of EU funds to be given really more higher priority, and so we finally get some accountability. So I'll stop here, Ander.
Thank you very much. No. We will come back to all of your, let's say, conclusions, because I think these are very, very important, and it gives us actually the perspective to continue the dialogue in the facilitated discussion. It was really very, very helpful. Thank you very much. And sorry for cutting you a little bit. But let's go to Monica from Poland. And let's see the Polish case, actually, how the Ombudsman Office was or still being involved in the assessment of complaints and about the EU funds programs. And what is your take actually about the role of the Ombudsman Office actually when it comes to the real actions like sanctions or any kind of implications? Monica, the floor is yours.
Thank you so much. So I would like to tell you some kind of cases we got in the Polish Commissioner for Human Rights. At the beginning, I would like to show you that Polish Commissioner for Human Rights is the National Human Rights Institution, independent body for supporting and protecting, monitoring the conventional rights of persons with disabilities, and also independent equality body. We've got three kind of complaints that were given to the Polish Commissioner for Human Rights. The first one was that we were talking with the Ines, so the misuse of these EU funds in the Łódź province with the building of the institutions. The second one is a completely new one because our local monitoring body addressed a complaint that they have a problem with application the EU funding because some schools and kindergartens, they are trying not to show that they are the special schools without giving this name, but the whole request is giving some evidences that it's going to be the segregation place. So that's the second part. And also we've got the third type of this request. It was a discrimination with the amusement park that got some EU funds. And at the end of the slide, you've got a part of a regulation within this park that people cannot use the entertainment facilities. It was the regulation at the beginning when you buy in a ticket. So if you are a person with disability, you can buy a ticket, but you can't really use this facility.
Monica, I think your slides are not moving. I don't know if that's supposed to be the case.
Oh my God.
If there's a problem, then I can always share as well, but just flagging.
If you can share it, it would be easier for me.
Okay, then please, yes, stop sharing, continue, and as you speak, I will share the screen.
Yes, just one moment. I stopped. And we can move to the fourth one. I'm really sorry, but it's not working.
It's fine, don't worry.
No problem at all. I mean, this is absolutely normal.
So what
Sorry?
would, yeah,
Okay, coming. Yeah.
one moment. And the fourth one. Yeah. So what was the biggest problem? We've got the concluding observations of the CRPD. And within this, the institutionalization process, we said that there is a critical stagnation because there was no strategy, no documents, and also the strong idea that these institutions should be transformed, but they should still exist in this idea. So we were trying to find any way how to change it within the Polish law. That's the idea. Let's move to the last one, maybe. I would like to be as short as it is possible. The 6th. Okay. Yes. So what are the competences of the Polish Commissioner of Human Rights? The first one is to try to find any monitoring body within the country that could change the practice. I'm sorry, but in Poland, the most effective way is to get a fine for their activities. So we're trying to address a request to the Office of Competition and Consumer Protection and the Regional Inspection of Trade. And also there was a problem because they said there is no such rule on the discrimination law which was connected with disability, so they cannot do anything. So they just refused to get any action. So we decided to address a request to the Plenipotentiary for Equal Treatment, how to change the law, that they can really make an action without these individual cases. But they also gave us the answer that the law is effective and it should not be changed. So we addressed the last one, the request to the Ministry of Development Funds and Regional Policy. And they said that they are preparing some guidelines how not to make the same mistakes at the beginning of a process and not at the assessment after the EU funds were used. So right now we have this kind of cases, how to apply the new EU funds, especially with this inclusion education. So we found that there is a Polish small regulation which shows that every place which is not made with the inclusion of all of the people is a place of segregation, and it's against the EU fund. So that was the idea, how not to give this money to the special kindergartens and schools. We will see in a few months how is it working. Thank you.
Oh, thank you very much, Monica. It was short, but again, in your case as well, we are going back to your presentation, if you don't mind, because there are some very important things actually in your presentation. But I don't want to abuse my role in that way. So I would like to open the floor to everybody, and then please ask questions. Personally, I also have some questions, but this is not so important now. Okay, jokes aside, so who would like to start? There are a couple of topics which you mentioned also actually in the chat. We can come back to that one as well. But let's see first actually that who has questions to these presentations, what we heard actually, these 4 presentations. Is there anybody who has some burning questions? No? Louis, nobody, right? I'm not missing anybody, right? Good. That's perfect. Then
questions as well.
Sorry?
The old questions as well, because Rita had some questions.
Yeah, we can start.
Stephen also now.
Stephen has Stephen, you want to say something?
Yeah, I just wanted to mention that we also have a program in place over the next 2 years to develop a specialist strategic litigation handbook on litigating breaches of the Charter of Fundamental Rights for persons with disabilities. So I was particularly interested, I think, in the FRA project, which I think we should link up on, as well as those of you at EQUINET and equality bodies who might be interested in actually pursuing litigation. And I'm talking here particularly about European Court of Justice, the Court of Justice of the European Union. Thank you.
Perfect. Thank you very much. Okay, then we can start with Rita. Rita, please, you wanted to ask something.
Yeah, can you hear me? I'm trying to turn on my camera.
Yes, no worries, no worries. Just speak.
Yes, I put in the chat. I can go back to my question. I wanted to ask regarding the first presentation on what was first the consultation process regarding the inquiry of the Ombudsman. And also we have already been finding that there are investment plans under the Recovery and Resilience Facility for institutions. In particular, there's been an announcement in the region of Catalonia to build 30 new institutions in clear violation of the CRPD. So I wanted to also ask if there will be any action, or how can we take action collaboratively to try to stop these investments from happening. Thank you.
If I understand well, your question is addressed to Valentina, right?
Yes.
Okay, Valentina, do you mind to respond?
Yes, thank you. There was no consultation in the way that we had consultation in the previous 2 inquiries that I was presenting. There was consultation with the members of the European Network of Ombudsmen. So because this was this is what's called a strategic initiative, which means it's not an inquiry yet. We were aware, and all ombudsman institutions on the ground were aware that the funds are being prepared, that the member states were submitting their programs that will be approved for funding. So it was really a start of this type of work for us, the European Ombudsman and the colleagues at the national level. So from that perspective, there was no consultation at the time, but it was being discussed, all ombudsman offices. And so very much the angle of, and you will see this in the decision, is on transparency. So we know that the funds will start flowing. We know that the programs are being approved. How is the European Commission ensuring that the money is going where it needs to go? And as we've heard from the previous inquiries, what we're interested in is that it is fundamental rights compliant. So this was how shall I say, this is the starting point. This is the building block of this. And then you will see there's also something that we developed together with the OECD, the organization based in Paris, for ombudsman institutions to be following up on the transparency of these plans. So I think indeed, as you are mentioning, and we are hearing also from other colleagues in Czechia and in other places, that there is a problem with this type of funding as well. It is going towards institutions. It's not going towards the institutionalization. So we are aware of that. I think our colleagues on the national level are aware of that. So there should be work coming out of this. Of course, we invite everybody. It's always the easiest if you submit a complaint, but the Ombudsman is aware of that. Our office knows about this. And like we have said in the concluding wording of this decision, we will keep monitoring this. This is just the starting. This, the transparency angle is just the starting point. So thank you very much for raising it.
Thank you very much. If you don't mind, we will go back a little bit to the questions of the capacity. We have been discussing actually this question a little bit, but as I understand, Adam, you put something in the chat as a very concrete proposal. What should be done actually about improving the capacities, and also actually to involve the fundamental rights bodies actually in the EU funds operations. Adam, are you with us?
Yeah, I'm with us. So the thing is that one of the very concrete recommendations is that if there is no possibility and a support with funds also, not only but also, because it's quite crucial, for the human rights bodies, rights institutions to participate meaningfully in monitoring committees, I would rather deem that as not being in line with the enabling conditions, very strictly speaking, because when we see on the recommendations that each of the national, I would say, states get, they usually get also the monitoring of EU funds. Poland did get a very, I would say, radical and point that said critical stagnation and lack of determination in the process of DI. So it cannot go in diplomatic terms more fierce than that. So I would say, and I think it's very crucial to just say that when one of the enabling conditions is on monitoring, how can we not have those? And another one, the second one is, I would say, very pragmatic. When we use millions of EU funds, how can we not use even 1% or 2% of the total budget for social inclusion, only in social inclusion projects, ERDF and ESF included, for monitoring, independent monitoring? If the scope of the problems and the violations is, well, we would say quite vast, it's very effective within the line of the rule which governs all of the EU funds, which says best usage of money. In this regard, this 1 or 2% would be not only the case for this anti-discrimination, but it only would be the best, I would say, effectiveness of the usage of money. Thank you.
Yeah, thank you very much, Adam. I think it's a very promising, or I don't know how to say, a suggestion. What would be important actually with this suggestion, that we keep it in mind that actually European institutions will launch the discussion about the post-27 regulatory framework kind of soon. So it could have been already actually launched, and this suggestion should be included actually in this package. So as soon as consultations will be launched about the new regulatory framework, about the post-27 time, then actually this might come. Because the problem is now, without going too much into technicalities, that the criteria of the enabling conditions, they are not mentioning that. So when you are saying that the enabling conditions should not be adopted, which is a very fair point, but just understanding the logic, how the Commission works, and member states, they are understanding the regulations, it should be very precisely mentioned in the criteria of the enabling conditions. Then we will have actually this 1% or 2%, whatever, funding actually for improving the capacities. And of course, the involvement could be much stronger. Anna, you raised your hand. Please go ahead.
Can you hear me now?
Yes, we hear you.
Oh.
Yes.
Okay, hello everyone. Yeah, I was actually, my question also refers to capacity, because I think that I was wondering whether any of the institutions present, including the Ombudsman's Office, have looked into the capacity of NGOs represented in the monitoring committees. Because I think, although I appreciate, the importance of equality bodies, I think that self-representation matters as well. So typically NGOs represent the groups that experience discrimination, for instance. So I think that what would be helpful, I think, is going back to the root, which is, and look at the delegated regulation actually that looks at the tools that NGOs and social partners probably as well have within the partnership regulation, and maybe look there if maybe that would be this hard law measure that could maybe enhance the tools that are at disposals of NGOs, because I think that what we actually need is hard law solutions, not just recommendations, because otherwise we can talk ourselves to death and nobody will really acknowledge our remarks, comments, recommendations when we have sessions of the monitoring committees. So I think that maybe looking there actually and maybe updating or advocating an update on the delegated regulation would be important. So I was wondering whether anyone is looking into that. That is my question.
Yeah. Please, colleagues, please respond to Anna. But in the meantime, maybe we can continue with Chiara. I see your hand, Chiara.
Hello, everybody. Thank you, Ander. Yes, I have a question. It's a bit related to what has just been discussed, also to Adam's intervention, to follow up to Adam's intervention. I was wondering whether anyone has experience with litigating or with trying to bring the whole issue of partnership principle or participation in monitoring committees to a different level, meaning to maybe complaints, if anyone has submitted complaints. I think Tamas mentioned that some of the members have submitted complaints, but I'm not sure if anything was related to general issues, issues related to participation of different bodies in the monitoring committees, for instance, where I think the legislation, it could probably be clearer, but there are already some elements that are set in law, in legislation, in the common provisions regulation, and are not implemented, or according to what we see, also are not being sufficiently implemented. So monitoring committees, partnership principle, and also enabling conditions. That's also another element that we are trying to assess as well in our work, to understand if the elements that are mentioned in the common provisions regulations related, for example, to complaints or to possibilities to raise issues of breaches of fundamental rights to monitoring committees, if there are actually arrangements in place, as it should be the case. And when this is not the case, if anyone has tried to bring it to judicial level.
Thank you very much. I see the hands of Inez and also Stephen. I suppose, Stephen, you want to reflect directly to what Chiara said. That's my feeling. Maybe I'm wrong.
Yeah, no, you're not. You're correct. Yes, we have tried, actually, in fact, in 2 cases, actually, before the Court of Justice of the European Union, focused against both Bulgaria and Hungary. We have pointed out serious weaknesses at the national levels in terms of implementation of the partnership principle. I have to say those were both part of wider complaints that the programs that we were complaining about were violating EU law, the Common Provisions Regulation. So the partnership is a component. There was very little consideration by the court of that itself, I have to say. Very little consideration by the Commission in the complaints of the validity of our issues around monitoring committees and the participation of civil society. So I think it's something that we need to work on. I would say actually in Hungary, we've seen kind of an acknowledgement of this problem at the national level. They've recently opened up the National Monitoring Committee, and the National Human Rights Institution has also been seeking greater involvement of NGOs as well to consult on these matters. One of the interesting things that happened recently is a colleague of mine went into one of these rooms and saw a huge number of NGOs they'd never heard of before. They came out of nowhere. This is a very, very experienced national lawyer who does know pretty much every organization operating here. So we were a bit surprised that it's actually quite easy actually to manipulate the partnership principle also as well. We've seen that here in Hungary. I think some of you were talking about the pressure of national authorities in other countries as well. So even if I think we make some pressure on the partnership principle, we have to go beyond the kind of idea that we just look for a list of representative organizations, because that's what the Commission is currently doing. Is there a meeting? Is there an agenda? And is there a participant list? That's obviously not sufficient, I think, to answer your question, Kira.
Yeah. Ines, please, the floor is yours.
Yeah, just a comment. I think people have too much giving too much importance to the monitoring committees because from experience, we just had recently this complaint on Austria, and there was the involvement of the Austrian Disability Council in the monitoring committee. And they have objected to a particular investment that we were complaining about. And the Commission first of all lied about it. Then when confronted with, their opinion, said that members of the monitoring committees can basically have a say when it comes to the criteria for operations, but not when it comes to the actual implementation of these criteria, as in particular projects that are going to be funded. So even if you do get to be involved in the monitoring committee and you try to stop a particular investment, you can be completely, ignored. So unless there is, unless the whole monitoring committees change, and maybe it's different in different countries when it comes to different funds. Okay, I see Adam is confirming about Poland. Anna, then something would need to change with the monitoring committees in general. And I had another thought, or maybe a question, maybe somebody can address, because as a result of our complaints, the Commission was saying that they will, they rejected that, but they will continue monitoring the situation in the country, including involving the National Human Rights Institution. Mm-hmm. And for example, Romania is a very problematic country when it comes to the rights of persons with disabilities and investments in institutions. And, I'm just wondering, for example, if the colleague from Romania has had any interaction, or their institutions have had any interaction with the Commission. And would they even be able to recognize all sorts of institutions? I mean, we're talking here about people with disabilities, but then there's Roma, migrants, in a way, you need to rely on civil society to report that.
Ines, can I interrupt you for a second? Because Csaba
done.
No, just Csaba messaged me just to say that he might have to leave. I don't know, Csaba, still you are around? Very briefly, maybe you can respond.
Yes, I'm here. Now Romania has a number of human rights institutions, and regarding to the question of people with disabilities, here we have actually 3 or 4 institutions who with competences in the field, and then there are different responsibilities regarding to the breaking the law or the rights of people with disabilities. Even in this year, we had cases which were managed by the prosecutor office, because there are criminal cases that we as an equality body we have the competencies to work on the field of the administrative responsibility that apply fines, but those cases referring to the rights of people with disabilities are under the responsibilities of the criminal code, and that's why the prosecutor office are handling these cases. And yes, I have to confess and share with you that in this spring and summer we had plenty of cases which were managed by the prosecutor office, actually, with accusation of torture of people with disabilities in different in different institutions. And yes, the main issue here is how the state is managing the desinstitutionalization of the people with disabilities, and that again in society there are views or even political parties who are in favor of maintaining the institutionalizations of people with disabilities. That's again, it's a longer process than it's comparable with desegregation on, for example, in access to education of the Roma people. It's not easy. It's more easier to prevent institutionalization or segregation than to desegregate or desinstitutionalization, and that's why I think that that's why I say that yes, we have these kind of cases, but most of them are not on the competence of the equality bodies. They are handled by the prosecutor office because these are criminal cases, and we have even sentences in this field. And I'm sure that after these new cases which were presented in this spring, even it was a huge public debate and political crisis because of these cases. I'm sure that this system is going to be improved.
Csaba, let me use this opportunity that you are still with us for another 2 minutes, if you don't mind. And maybe we can jump to another very important question, which was raised actually by several speakers, that we are experiencing actually a different interpretation of the EU law or international law by different institutions. So even if the fundamental rights bodies, they would say, or NGOs, they would say that is a discrimination. Let's give the example of institutionalization, what Stephen mentioned. Countries like Romania, Hungary, Slovakia, many other countries, they would say, no, this is what they are doing. It's compliant actually with the EU law and international law. How do you see your role actually in this as an equal treatment body or an anti-discrimination council to mitigate or to do something actually with these different interpretations?
We have to test the justice system. I used to say when we have this kind of different interpretation that let's testing, submit a complaint and let's bring the case in front of the judge, the national judge, and then we have other instruments to go to the Luxembourg or to Strasbourg. That's it's an open. But just the staying like this and saying that the state has an interpretation, the NGOs has another one, the equality bodies a third one, and then so on, is not a way how to move forward. Usually we start an ex officio cases or we receive complaints. That happens in Coman Hamilton case, for example. For years that it was a question on LGBTI rights and issues, and then we as an equality body, informal and official, we encourage the NGOs and the stakeholders to let's test the justice system. And this testing can start with a complaint to the equality body if the equality body has these competencies, or direct in the court. And then we, at the end of the day or the end of the case, we are going to have an interpretation. If we feel that the national courts or they do not have this expertise, or they do not have any a proper interpretation in line of the international standards, then let's have questions raised to the European, the Court of Justice of European Union. That's an important tool for us. That's what I see as a good way.
That's perfect. Thank you very much. I think it will be one of the most important takeaways actually from this webinar, that this different interpretation, inconsistency as we call it sometimes, should be handled actually in a more constructive, more strategic way. Okay, so but thank you very much for your participation.
I thank you, and I'm sorry I have to go. The students are ready.
No worries. Thank you very much. We will continue this discussion. Thank you. Bye-bye. I see the hands of Robert and Stephen. Robert, maybe you can come in.
Sure. Yes. Thanks a lot. Yeah. So just I sort of replied to Anna's question already in the chat, but we will in our upcoming report on EU funds also address the role of civil society and the need to give them the proper support, also to build their capacity. So that will be handled. I think it is important just to make a general point to have more strategic discussions on this, such as the one we're sort of having now. So when the report comes out, I'd really like to see if we can start a process of discussing this further. Thanks.
Okay. Thank you very much. Stephen?
Just to support the point of Csaba, that we do need a legal determination. That's my thing. In Romania, the questions that have happened earlier this year, of course, they've gained public attention, but that's because you've got evidence of torture, which absolutely shocks people. It gets in the news for a little while, and then it goes away ultimately. That's not sufficient in our experience, even to change EU policy or monitoring of the funds, because yes, it's embarrassing for the European Commission. There's even been Al Jazeera documentaries about this over the years. It's not been sufficient to get real change. Why? Because there are still people who are committed to allowing the funding to go. There are still people managing the funds who believe that institutionalization is acceptable and that does comply with European law. That includes lawyers in the Commission's own legal services. I have to say, I've read many of their letters. But the other thing that's really important to say is that those lawyers are not those who determine what is the substance of European Union law. The substance of European Union law must be authoritatively set out and determined by the Court of Justice of the EU. Now, we've tried to take a few cases on this. The barriers to reaching the Court of Justice are incredibly high for all sorts of reasons I won't go into now, on standing and all sorts of things. But one thing I do want to say is that every equality body here has a fast track route to the Court of Justice. Because of your status as an anti-discrimination authority determining complaints, you can submit questions, to the Court of Justice and get relatively rapid turnarounds before you make your own determination on whether or not there is a case of discrimination. Just because there is a criminal allegation at play does not prevent you looking at the systemic question: is EU funding here supporting the institution in which torture may be occurring? We had a case here in Hungary, also similarly. So you can also be creative on this. You can approach the Court of Justice. None of you have done, because we have searched. We would encourage you to do so. We would be even happy to help you draft the questions. Thank you.
Okay. Thank you very much. I think we can continue the discussion actually from this point of view, and it's very good if I understand well, Tamás, you raised your hand. And maybe Valentina, Monica, Tamás, what do you think actually about this proposal from Stephen? And also maybe you can reflect on what Csaba said. So the basic issue here is the inconsistency of the interpretation of the EU or international law by different institutions. What the EQUINET Ombudsman offices they can do, how they can help actually to handle the situation. We can start with you, Tamás.
Thank you, Andor, and thank you, Stephen. It's also a direct response to you, Stephen. I think it sounds like a very attractive proposal. I'm just afraid it won't work. And the reason for that is that it has been tried, and the Court of Justice has accepted on one account, I think, in the case of Ireland, but it did not in the case of Bulgaria, a preliminary question, which leads me to think that it's only a very narrow group of equality bodies that would actually be able to do that. So as attractive as it may sound, I think we can actually encourage that for those equality bodies that have a very, very judicial profile. But actually, among our membership, that's an extreme minority, if any of our members can actually do that. The equality body, the Workplace Relations Commission in Ireland, that has been accepted as a court or tribunal, is not our member. Our member is the Irish Human Rights and Equality Commission. And the Commission for Protection from Discrimination in Bulgaria, that was the other one that I know about that tried and which was refused in 2014 or 2013. That's our member, but like I said, even though they have legally binding decision-making power, which you could argue that it's effectively a tribunal, still the Court of Justice did not accept them sending preliminary questions to Luxembourg. So I think that that is something that we can discuss, and that is something that we definitely would like to strengthen equality body powers to do that.
Okay.
As a matter of fact, I think that but that's a question that leads very, very far. But I think that the Luxembourg court is access to the Luxembourg court is extremely restrictive. You have to be involved in the national level process, which really complicates things. And there is no opportunity, no possibility of filing any amicus type third-party interventions, unlike there is in Strasbourg at the European Court of Human Rights. So I think that's definitely something that's not playing to our advantage here. But after this long rant about this, I also wanted to mention that I think one member I can definitely think of is our member in Latvia that has taken cases to the Constitutional Court, particularly on disability and institutions, if I'm not mistaken. And I think it's definitely a route that we should favor and that we should strengthen. That's definitely the role of equality bodies, to try to get more clarity of the law, and of course to further the interpretation that's uniform and that complies with international and European law. So I think that's definitely a way forward from where I stand.
Tamás, would you agree actually that in the future capacity building activities of EQUINET, this question will be more, let's say, included, and actually when you are I don't know, applying for funds and doing whatever things, actually this question will be more discussed actually in your activities, what just Stephen mentioned. So would you agree actually with this? Can we work actually on that in the future perspective?
Well, it's hard for me to commit right here and now, but I think that there is a growing understanding with the growing role that is given to equality bodies with regard to European funds. I think there is also a growing understanding in the membership, and as I'm working for the EQUINET Secretariat based in Brussels, a very small secretariat, we are definitely of the opinion that this should play a more central role in the work of equality bodies. So this is why we published this report last year, and we organized a series of small workshops, one of which you attended, of course, also, Andor. And we continue to do so. Yeah. We intend to continue this work. I think with this remark, I might have frozen Andor, actually.
I was going to ask whether Andor was still there. he'll probably jump back in. In the meantime, if anyone else has another question or like wanted to raise another point.
I am back. Sorry, it's my internet again. That's or maybe the rain in Belgium is killing everything, but it's absolutely normal. I don't know what you said, Louise. Can you repeat? Sorry, I
was just going to offer it in case other
okay
question to react. So that's it. You're back.
Would you mind actually if we go to Valentina and Monica and we will go around actually the same questions about this inconsistency of different interpretations, and I would even add actually that if the UN CRPD committee has, or that's an example, has already actually interpreted the UN CRPD and member states they are not using this interpretation, then what is your position as Ombudsman Office? What you would say to the Commission or to the member states that, guys, actually we have an interpretation from the committee which is responsible actually for this legislation. So what is your position actually in this regard? Valentina, can we start with you?
Yes, absolutely. And you actually very much preempted what I was going to mention.
So
While no worries, while I cannot speak for the national level, I'll speak what we do, what our mandate is, and our mandate is to hold the EU institutions to account. So when we go to the EU commissions, this is exactly what we are doing. We last time when the EU was being reviewed by the CRPD committee, and there were the concluding observations, which actually points out where the problems are. This is exactly what we did. We took the list and we opened a number of own initiative work on some of these issues to engage with the Commission on. And so indeed, in this case, it's an excellent exercise to remind them what the interpretation is, where the issues are lying, and actually what are the standards. So there's no misunderstanding. So we do use this, we do use this very actively in our work. And next year we will be awaiting the new concluding observations. So we will plan to do the same. And that really sensitizes the EU bodies, institutions, and reminds them what the standards are. We also very often do this in our work. Also, we're responsible when there's EU staff cases, right? Persons with disabilities or who have dependents with disabilities. So we use these standards as well and the interpretation of the committee.
And just before we are going to Monica, outside of the disability field, you are, as a European Ombudsman Office, you are using the same, let's say, approach, like in Roma rights or refugee rights. You're using the same approach, meaning that if the Commission, the Commission is not following actually, let's say, the authoritative bodies' interpretation of the law, then you are reminding them.
Yeah, absolutely. No, we follow what are the developments, case law. Yes, absolutely.
Okay, good, because we see actually problems not only in the disability field with this kind of inconsistencies. The school segregation was mentioned before, and actually EU funds are building segregated schools for Roma, for example, in many countries, saying that basically this is inclusive education. This is actually the framework how member states they are interpreting, let's say, the inclusive education. But let's go to Monica. What do you think about this question in Poland?
We are using this recommendation as far as it is possible. So also in the judicial cases, and also when we are addressing some ideas to the ministries. And one of the cases when we used them in the judicial one was that with the administrative court, it was about the education and the idea how to travel to the nearest school. And it was really useful, and the court followed these recommendations. So it could be really useful, but as a Commissioner for Human Rights, it is not really easy to be a part of this judicial process because our competences are really limited to some kind of cases. So that's the biggest problem when we want to initiate the process. Some kind of these cases, we cannot initiate them.
But just coming back to the same question, if Poland is not following the concluding observations from the CRPD committee, then can you do something? Do you have any legal tool actually to push? I'm talking about the scope of EU funds, of course. So can you do something? Can you let's say enforce some legal tools?
We do not have some legal tools. Only we can do is to inform the European Commission that these are the standards and Poland do not follow them. And that's the only way we can inform them.
Yeah, okay. And unfortunately, we heard from Ines actually how the Commission is responding to these recommendations. All right, okay. There is one more. Yeah, Luis, you want to say something?
I have a question, but you can continue first.
No, please go ahead, go ahead.
It was for, I guess more for Valentina, or others as well, potentially. In the migration field, we are likely going to see very soon some new standards on migration, migration management, asylum, and all those things, which will legitimize certain practices, including proliferation of detention and other types of procedures that will increasingly use European funding. So I guess, but those practices will not be aligned with the Charter and other fundamental rights principles. I guess I'm just trying to see in terms of future perspectives around inconsistencies in EU law and some EU laws that we would not consider to be fundamental rights compliant in the first place, and then Charter obligations as well. In how far with how we can tackle that potentially around future complaints. So anticipating that we will see increasingly more problems with the implementation of the Pact on Migration. I don't know if that question makes sense or if it's too early to already raise it.
I think it's a very important question. Valentina, can we go back to you actually about this? Because it's true that we are, and Chiara, please come in actually, because you are also following very closely the pact. So as soon as the Pact on Migration will be adopted by the Council and the Parliament, we will see more problems as no room for maneuvering actually on in the scope of complaints, as the law will say that many things, what Luis mentioned, which will be already actually, let's say again, adopted in the law. So what we can do in this case?
Well, we will not be commenting on the law itself or the quality of the law. I don't think that goes a little bit beyond our scope. But of course, we can have complaints filed to us. We can also open own initiative inquiries. And actually, we have a line of work. For example, vis-a-vis Frontex as an agency, we have a line of work that spans almost like almost a decade ago. Actually, the European Ombudsman is responsible for them having a complaints mechanism. This is something that resulted from one of our inquiries. And then we have more contemporaneous work. Also, you will see the Ombudsman commenting, for example, the inquiry, the own initiative inquiry presented. I think an important line of what the Ombudsman was saying was about, we see that you have some improvements in the setup or the monitoring of these funds there, but it's very important what's happening in the day-to-day. How is that impacting the lives of the people who are in these reception facilities that actually seems to feel like detention facilities, which should not be the case. So we have these tools to comment, to receive complaints, or to open own initiative inquiries. And indeed, we have to see, and we certainly count on you, on many of your organizations also to be approaching us with us. To us in order to look into the matters and to ask. And as the Ombudsman always says, one of the most important prerogatives, one of the most important capabilities that we have is that we can see the documents. This is an important power of our office. We are entitled to see the documents, to see the discussions, everything that is available. So then we can comment on it in our decisions.
Right, perfect. Chiara, you want to mention actually this point?
Yeah, thank you. Just to go back to what Luis said, I think there are already a number of issues when in the immigration field related to the use of EU funds or misuse of EU funds. So maybe there will be more issues. That's probably the case. But I also think that there will how can I put it? Like the issues of deprivation of liberty, for example, or the use of detention in unlawful matters. I think maybe this will increase, but I think that that's maybe a separate issues that will be, I hope, dealt by European courts from from the perspective of fundamental rights abuses. Then the issue of youth funds, that's probably something that is already ongoing and will maybe be used even more. Can I can I just ask a question to Valentina, if that's possible? Yeah.
That's the way now. Yeah.
Okay,
Yeah,
great.
exactly.
I was wondering if you think that the framework set out by the horizontal enabling conditions to raise issues of fundamental rights breaches in the context of the use of EU funds, if it's something that is could be used by organizations, if it's working, and if you have if you are following that in your office as well as something that can become more functional, or maybe there is already some good examples.
I am not aware of the details of that, so I might need to come back to you to check on what our views is, or if we've commented on it in any of our decisions. So sorry, I don't have the immediate answer, but I will take your name down and I'll come back to you.
All right. Okay. I have one more. For me, that's an important, and probably some of you would agree with me. One important question what we need to discuss a bit more, because we are facing problems actually as the Commission, together with managing authorities, they are, let's say, identifying discriminations. So the issue about the discrimination, whether it happens or not, it's basically identified by funding authorities, managing authority, and the European Commission. We have seen it in many complaints. Stephen, Ines, please correct me if I'm wrong, but that's what we've seen. We contacted the managing authorities in a particular country, and the managing authority does not see any problems actually with the discrimination. So my question is, which institution is entitled to recognize, to identify the discrimination? Which institution is that? Is the managing authority, which is responsible for the management of EU funds, or the equal treatment bodies, ombudsman, like the fundamental rights bodies? So, and this question would lead us actually to the question, the involvement, of course, in the equal treatment bodies and ombudsmans in assessing the complaints and monitoring committees and everything else. But first of all, what do you think about that, Monica, Valentina, Tamás, again? How much managing authorities, EU funding authorities, they have the competence to identify the discrimination? Who would like to start? Valentina, sorry for abusing you. Can you start? I'm so sorry for that.
I got a little bit lost in the question. Could you
Yes.
summarize it again about
Exactly.
the managing authorities? Yeah.
Yeah. So the managing authority, which is responsible for the management of the funds in Romania, Hungary, wherever,
Yes,
right?
yes.
And actually, we are receiving letters from the Commission, when the Commission is saying they ask the managing authority in Romania or Hungary, and they don't see discrimination. But it's not, it doesn't mean that they contacted the equal treatment body or the ombudsman. No, this is their position.
Yeah.
So what do you think about that? How much the managing authority has a competence to establish or identify discrimination?
So I think, if I understand correctly, the question, I think this is related to something we have commented upon in our own initiative work, in the sense that we have concretely asked the Commission, in the monitoring process, when you're sourcing your information, make sure that you do not speak only to the national authorities, so the representatives of the concrete member state, but make sure that you have information from the local non-governmental organizations. Make sure that you have information from ombudsman and whatever the name of the human rights institution is in the concrete country. So I think for us, clearly that is an important part of strengthening the monitoring capacity of the European Commission. Yeah, I think for us this is really key to So having the right amount of information.
All right. Okay. But just to be sure that I understand well, but if the Commission, when replying to Ines or Stephen or any other organization about that your complaints is not valid because there is no discrimination, because we asked the managing authority, that's it. Is it not? Is it acceptable?
I think it will not be acceptable based on everything that we're talking about, right? Or in the sense, it will not. It seems that what our inquiry, what the Ombudsman has said, is not coming together into it's really not sourcing this independent information. So it should not be acceptable. Yes.
Okay, because our intention would be that it should be made like the compulsory action. So without the opinion of the equal treatment body or Ombudsman Office, you cannot identify discrimination, whether it happened or not. But this is just a proposal. Tamás, you raise your hand.
Yeah, and so did Stephen actually before me, but whatever. So there are people who are much more knowledgeable in how the Common Provisions regulations work than I am. But my impression is that a major issue with the managing authority deciding on whether or not something is discriminative is that it's slightly circular. I detect a conflict of interest where I'm not sure that the managing authority would necessarily be very much inclined to find discrimination, because that just adds to their work very simply. Yeah. That's one thing. Then the other thing, I'm not sure whether this can actually be called legally problematic, or whether it is in line with the letter of the Common Provisions regulations. Like I said, I'm not a good enough expert, but I would certainly think that it's not in line with the spirit of what it should be about. That's one thing. And then the other thing I wanted to mention is that I'm not really aware of equality bodies being systematically included in dealing with the complaints in any of the countries. Again, it might be possible that I'm missing something, but they certainly provide a parallel route. So it doesn't have to, it doesn't mean that if they are not involved in this process that is set up for the overview of the EU funds, it doesn't mean that they cannot observe irregularities and they cannot challenge them, not the least because it's a double issue here, because it's not only that the EU funds are being used for what the EU funds are being used, but it's not just the issue that the EU funds are used for it. The underlying issue that segregation, even if you don't use EU funds for that to perpetuate it, it still remains illegal. So equality bodies can detect, for instance, that a new school is being built and it leads to segregation, or it's a segregated school. It doesn't have to be with EU funding. Even if it is not with EU funding, it is going to be illegal. Same with institutions built for persons with disabilities or older persons or whatever. So I think that they can definitely play a role, and this is on the very limited knowledge I have. This would be my 2 cents on the issue.
That was very, very helpful, Tamás. Thank you very much. Stephen, please go ahead.
Sorry to be the lawyer in the room also, but to say that it's impossible to say who is the final arbiter of the definition of discrimination under EU law, simply because the nature of EU law itself respects the institutional architecture of member states as long as they are sufficient. And that's where I would say is the more important question, not who decides, but is the member state architecture sufficient to be able to do so in line with European and international law? And so this is very complex. I mean, Germany would push back, for example, right? It's got federal structure, it's got a highly complex system of anti-discrimination authorities. But in terms of getting a consistent interpretation, I do think that that where we need to be looking there is not so much at all of the national authorities or the European authorities or the combination of them. It seems to me that really the judicial authorities have an important role. Tomasz mentioned the difficulty of getting to the Court of Justice, for example, and that's absolutely true. But actually constitutional or Supreme Courts may have the most authoritative role, I think. And the issue has always been, as it always is, for validity. We're 20 years doing strategic litigation in this field, is getting those questions before the court takes time. And I think we do need like a complex legal strategy, essentially, to get what I think your intention here is, which is to get a greater common understanding of an authoritative determination, which all authorities would be needing to apply, national, member state and European Commission and other bodies. So yeah, sorry,
right,
not a helpful answer probably.
no, that's very, very helpful, but we are, I'm talking more about myself, we are enjoying actually this position as not a lawyer, so I can be very flexible and very, how to say, I have lots of initiatives. So you are a lawyer, you will stop me. That's perfect. I think it's a good cooperation. So because I think still we can come up actually with this type of, let's say, proposal, or to make some advocacy around these questions, that without a proper involvement of the fundamental rights bodies, there is no how to say, there is no room for managing authorities actually to decide whether this is a discriminatory treatment or not. So, and I like very much actually what Tamás said actually about the spirit of the common provision regulations would very much go against that. So I think we can work on this issue as well. We are a little bit running out of the time, so please guys tell me actually if we missed something and if you want to raise any other topics. Probably everybody getting very tired. Very good. That was the whole, how to say, objective today. It's great. So is there anything else what we missed? If not, I think Michelle, I've seen actually your comments in the chat, and I completely agree with you. As we mentioned at the beginning, today we try to discuss actually the role of the fundamental rights bodies in this whole discussions, but you're absolutely right. The organizations and also, of course, communities like Roma and people with a migrant background, they are facing very precarious situations all over Europe. And especially the political climate actually now, what's going on actually about the migration management and the whole policy discussions about the pact on migration would not be helpful. So, but this is one of the main reasons why we are running actually this webinar, and when we are continuing this job, actually to reinforce our capacities and efforts, because the situation is not necessarily improving. You may argue with me, but that's my personal interpretation. That's really not improving. So we need to be even stronger than before. And I just would like to highlight that again, we are continuing this discussion. So we started actually with some project examples in September. Now we organize this webinar where we discuss actually the role of fundamental rights bodies, and the next one will be probably focusing actually on local examples. So we would like to continue the discussion actually about what member states are doing, because these whole interpretation questions, consistency questions should be discussed from the point of view that what are the policies, regulations, guidances are produced by national governments. Because we are facing many times actually issues around this question that, yeah, but basically the Polish disability or DI guidance is not in line with the CRPD, then what to do? What's next? So that's actually what we would like to discuss. Actually, I see that a colleague from Greece joined us. If you have a bit more patience, actually, just Georgios, do you mind to introduce yourself? He is a lawyer actually from Greece, who is litigating actually local authorities about the segregation and evictions of the Roma communities. Do you mind to introduce yourself, Georgios, and to say a few words actually what you are doing in Greece?
Thank you so much, Sandor, for having me here. I'm sorry that I couldn't follow this whole conversation, but I was able to catch up from 4 o'clock. So I think I'm not very knowledgeable on the discrimination with regards to EU funding. I'm representing today with you an organization of lawyers. It's called Pro Bono Publico, and we are conducting, we're engaging in strategic litigation mostly on human rights judicial fora, the European Conference on Human Rights and the UN Human Rights Committee, mostly pertaining to issues of forced eviction, police abuse. The topic that you raise is very, very interesting, and it is very impactful on Roma inclusion, participation, and equality. The only insight I can offer in this background is the fact that the European Commission has taken a step forward with the EU Roma strategic framework, imposing the necessary condition, the enabling condition on the CPR that you are discussing. That requires to have actually non-segregated education, socio-spatial inclusion, and fighting housing segregation, and mainstreaming at regional and local levels, one of the most important issues, especially for what they are called cluster 1 countries and cluster 2 countries with major Roma populations, such as Greece, meaning that we have to wonder when we are implementing policies, first of all, when they are mainstreamed, for example, a social housing policy, as Greece does not have a social housing policy, to be able to mainstream it for Roma communities. But when it does, the issue here is when it uses EU funding, this is a consideration, how the Roma populations are targeted, because it is a different thing to have social housing or green policies for the mainstream population, but have segregated housing or reproduce segregated housing or secondary segregation, for example, in housing, when it comes to the Roma communities. And I would say that it's also a dual language when you are funding as a member state, even though it is not stemming from EU funding, segregated housing, for example. And when you you employ EU funding, you will have a different language, or you will have different policies. And also, when we are talking about, for example, segregated education, should the EU funding, for example, ESF Plus would fund, I don't know, a multicultural project of inclusive education on a segregated school? So these are questions that you have to do with monitoring of the national Roma strategic frameworks. But the national Roma strategic frameworks, one aspect of their failure was that they were not mandatory. They didn't have any legal obligations. So since the European Commission asks not only for adhering to the regulations and the enabling condition, but also on specific targets and specific quantitative targets, then I think that the key here to adhering that the EU funds do not either primarily or at a secondary level support segregation. The key is monitoring and reporting. So these are general issues that I want to address.
Thank you very much, Georgios. Would you mind actually to send us, and then we will share it actually with the participants, because we will not have time now, some information actually about your cases, what you are running actually, like legal cases against local authorities in Greece, because we were very happy actually to meet you, as the Roma issue in Greece is not so, let's say, visible. So if you can highlight us and if you can contribute actually to the discussion from that point of view, that would be very, very helpful for us. So please send us actually some information which we will share actually with the colleagues, because litigation was one of the important, let's say, conclusion today, as we are facing lots of difficulties as let's say European or international law is not properly implemented by national organizations. So we would need actually your let's say input contribution to this dialogue. Thank you very much, Georgios, for joining us.
Definitely, Andrew. If I may say just that our focus is mostly on forced eviction, so it's not very pertinent to your topic, but yes, to do with stopping on Rule 39 of the European Court of Human Rights and on Rule 9.2 on a recent case of police abuse that we focus on Roma before the Committee of Ministers of the Council of Europe on the implementation of judgments.
That's perfect. No, it's absolutely, let's say, would fall into the scope actually of our action. So thank you very much. Guys, thank you very much for participation. And we will come back to you with some very short conclusions of today and some takeaways, actually, what we discussed, and we will continue. But thank you very much for the speakers in particular. Actually, I would like to thank you actually for your efforts and your discipline actually to take the time.